Okay, well, welcome everyone. I'm Diane Hoffman, and I'm on the faculty here at the law school and direct our law and healthcare program. And it's my pleasure to welcome you here today to the second in this year's Rothenberg Healthcare Law and Policy Speaker Series. We started this speaker series last year. It's named for Karen Rothenberg, who is the Marjorie Cook Professor Emeritus of Law and founding director of our law and healthcare program, as well as former dean of our law school. The series was also established with funding from the Karen Rothenberg and Jeffrey Seltzer Law and Healthcare Program Endowment, and it focuses on contemporary issues in healthcare law and policy. And thanks to the virtual format, we've been able to bring leading health law and policy experts and scholars and practitioners together with a multidisciplinary audience of lawyers and ethicists and policymakers and clinicians. And we're very pleased to have you all here today. My job is simply to give you a little bit more information about this series. Like I said, this is the second in our lineup for this year. Earlier this month, we had Dr. Eric Green, who is the director of the National Human Genome Research Institute, who spoke about challenges and opportunities in the new field of genomics. And kind of going on a genetics theme here with also today's talk from Professor Lisa Ikemoto, who will be introduced shortly. But before we get to Professor Ikemoto, I wanted to also mention that next semester, we also have two additional speakers in the series. In February, we'll hear from Dean Dana Bowen Matthew, who is the Dean and Harold Green Professor of Law at George Washington University, who will be speaking on the topic of health disparities. And then at the end of March, Ruth Faden, who is the Philip Franklin Wagley Professor of Biomedical Ethics and the founder of the Berman Bioethics Institute at Johns Hopkins University. So I hope you'll also tune in for those two talks. But I now will turn over today's session to my colleague, Matiange Sirleaf. Professor Sirleaf is a member of our law and healthcare program faculty. And she teaches and writes in the area of global public health law, among a number of other things. So Professor Sirleaf.
Thank you for that introduction, Diane. It's my pleasure today to be able to introduce Professor Lisa Ikemoto to speak with us today about the reproduction of race. Professor Lisa Ikemoto is the Martin Luther King Jr. Professor of Law. She teaches bioethics, healthcare law, public health law, reproductive rights, law and policy, and marital property. Her research areas include reproductive rights and justice, healthcare disparities, and science, technology, and the law. More specifically, she focuses on the ways that race, gender, disability, and wealth mediate access to and impacts of biomedical technology used in healthcare. Her recent work addresses reproductive technology markets, the role of provider religious exemptions in healthcare inequality, eugenics, and reproductive tourism. Professor Ikemoto has faculty affiliations with the Aoki Center for Race and Nation Studies, the Health System Bioethics Program, the Feminist Research Institute, and the Religious Studies Department. She is a graduate of the University of California Davis School of Law, where she received her JD. She got her LLM from Columbia University and her BA from the University of California, Los Angeles. We are so pleased to have you with us this afternoon, and I'll turn it over to you now. I will also just note, if you guys have questions during her talk, you can go ahead and just put them in the chat. After she speaks, we will open it up for broader Q&A. Thanks.
Thank you very much. I'm really honored by the invitation to speak, especially hearing the list of other speakers who are part of the series. And I'm really especially pleased to thank Karen Rothenberg for her mentorship and her friendship and her leadership over the years, although we won't talk about how many years that's been. And also, as sort of in Karen's footsteps, as she has done at many key moments in national discourse and in her career. I am here to provoke a discussion, hopefully a productive one. So I'm going to share my slides, hopefully now. All right, did that work? Okay. Sorry. All right. So Black Lives Matter and the pandemic have prompted widespread recognition that structural racism contributes significantly to health disparities and healthcare disparities. It's not something new. We've known this for over 240 years in the United States. So the question is, or one important question is, what is it that's been preventing us from seeing all the obvious forces outside our bodies that impact health and create these healthcare disparities? So I'm going to talk about one factor, the belief in biological race and its resurgence in the past few decades as genetic race. In the late 20th century, the belief that racial groups are biologically distinct latched onto the genome, the human genome. So what we have now is a persistent belief that racial difference is embedded in our genes. So here's my core point. I think that property rules and concepts have contributed to the new biological race and to the rapid proliferation. So I'm going to start by talking about an old foundational property case. It's called Johnson versus McIntosh. And the facts of this case arose when the United States was forming and when it was a new country. So it considers, in this case, the Supreme Court considered two competing claims to land in Southern Illinois. The original Johnson, the predecessor of the named plaintiff in this case, owned shares in the Illinois and Wabash Land Company. He was a land speculator. The company was created for land speculation in anticipation that the British would lose the fight. The company purchased land in the early to mid 1770s from the Illinois and Piankeshaw tribes in the Illinois region. McIntosh later purchased land from the US government, and at least ostensibly, those two purchases conflicted with each other. In other words, they were ostensibly for the same piece of land. I'm saying ostensibly because there's a legal scholar who's done some interesting work showing that, in fact, there was no overlap in the boundaries of the land, or very little overlap. And this was probably some collusion in getting this case up to the Supreme Court. But this case gave Justice John Marshall the first of three opportunities to issue a set of decisions which are now known as the Marshall Trilogy. And collectively, they set out core principles that established the legal relationship between the US government and the tribes of North America within the United States. This case in particular established a legal pathway for depriving tribal claims to land in favor of claims by the US government and those who acquired land from the US government. So the court starts its analysis by talking about this principle of discovery of North America. And I picked this particular image of a painting called DeSoto Discovers the Mississippi River because it so clearly reveals the irony of claiming to discover and being recognized for discovering a land that's clearly already been discovered and claimed by other people. But the Supreme Court nevertheless writes its opinion that says that discovery gives title to the government whose subjects discovered the continent. So we're talking about European nations here. It's subject to what the court calls the Indian right of occupancy. And in the next part of its analysis, the court makes it clear that the Indian title of occupancy is something very thin indeed. It can be extinguished, not by its own volition, but by that of the country that's now being recognized. So it gives an exclusive right to extinguish the Indian right of occupancy, either by purchase or by conquest. And the court in this opinion goes with conquest. So the justification for this analysis and for the decision in this case rests on the principle of scientific racism. And you can see it.
I'm sorry to just cut in. I don't know if you're advancing the slides, but we can't see it on our
Oh,
end.
you can't?
No, so the beautiful picture you just described, we weren't able to see.
Oh, thanks for letting me know. Okay, let's see if I can do it here. Does that work?
Yes. we can
Okay.
see. Thank you.
Okay, here's the slide I just described. DeSoto discovering a river that's already been seen by others and used by others. And then here are the slides describing the rest of the court's analysis. Thanks for letting me know. And then here's where I thought I was. So the court's justification and some of its language for its conclusion that McIntosh in this case wins because he took title directly from the US government, not from an earlier purchase from the Illinois and Piankashaw Indians. So in other words, the court concludes that the Illinois and Piankashaw Indians didn't have enough, something like ownership that they could then transfer to Johnson in this case, and therefore Johnson's claim is no good. What he received was an extinguished right of occupancy. So the language in this quote, is based on the principle of scientific racism. And I use an old image behind it that shows this sort of how the scientific racism was depicted at this time, that we had 4 biologically distinct groups or populations of people in the world. And this is sort of the description of the Indians, the indigenous people, one of the 4 groups recognized in this. And what you can see is that the court's conclusion that based on this notion of scientific racism, Indians by nature lack the ability to cultivate, build, make land productive, and therefore were not fit to own. They were ungovernable by nature, if you will. So scientific racism and labor theory, which is at the sort of heart of this analysis, are both products of the Age of Enlightenment. And here the court uses them together, echoing John Locke in the 2 treatises. And they're used to explain an old core property principle, relativity of title, and to validate removal of land from tribal authority in favor of the United States, and simultaneously facilitate a land rush. So relativity of title is a core concept of property law. It's used to settle competing property disputes and to allocate interests in a hierarchical fashion. Scientific racism is not always paired with property rights or with relativity of title, but it has persisted over time. So my point here, now moving us into sort of the modern era, if you will, is that in the emergence of the biotechnology industry, these property concepts, dominion, control, and relativity of title, and biological race have been reunited. So this is a slide depicting John Moore, who brought a lawsuit against the University of California. So the case is called Moore versus Regents of the University of California. In the 1970s, John Moore was diagnosed with hairy cell leukemia, a form of blood cancer, and he was referred to a doctor at UCLA. So he went down there. He was from the state of Washington, and Dr. Gold at UCLA confirmed his diagnosis and also noted that his spleen was grossly enlarged and recognized and recommended that Moore undergo a splenectomy before continuing his treatment. So he did. His spleen was removed, and he assumed it had been disposed of in the usual fashion. Over the next 7 years, Dr. Gold recommended, and John Moore complied with the recommendation, that he fly down from his home in Washington to UCLA to undergo further testing. And over the course of that 7 years, many cell and tissue samples were collected from John Moore. Blood samples, semen samples, bone marrow samples. Each time he went down to UCLA to be treated, he gave up these samples. He at some point asked, can I just have this done up in Washington where I live? And Dr. Gold said, no, this is important follow-up treatment. You must come down. And so he did. At some point near the end of the 7-year period, he received a form that asked that he consent to the use of his cells and tissues for research purposes and potential commercial uses. And the form indicated that would be applied retroactively. And he started asking questions. And there was insistence that he sign the form, and instead he went to a lawyer. And the lawyer did some research and found out that UCLA, on behalf of Dr. Gold and another researcher named Dr. Kwan, had filed a patent So they had created a cell line using Moore's cells, tissues, and genes called the Mo cell line. So it's named after the patient, John Moore. And they were in the process of obtaining a patent, which they then used to leverage agreements with pharmaceutical and biotech companies to commercialize use of the cell line. So John Moore brought the lawsuit. And initially he filed 13 claims. 2 of those claims made it up to the California Supreme Court. One was breach of fiduciary duty for failure to disclose the financial conflict of interest that Dr. Gold had. And the Supreme Court said, yes, you can proceed with that claim. The second claim was conversion. So it's a tort claim, but based on the principle, or at least the idea that John Moore had a property interest in the cells and tissues that were used to create this cell line and were ultimately patented. And the court denied that claim. And boiled down, these are my own words, but boiled down, the court used an analysis that looks an awful lot like the court's analysis in Johnson versus McIntosh. So I translated it into language like that of Justice John Marshall's in Johnson versus McIntosh. But basically what the California Supreme Court said was that the researchers discovered, and they discovered this because shortly after the splenectomy, John Moore's cancer cleared from the system. He had a very high level, an unusually high level of lymphokines, which are part of your sort of adaptive immune system, that enabled him to overcome the blood cancer that he had. And that's what they were going for, was a cell line that could produce lymphokines at a very high rate, the same high rate that John Moore's own immune system could do. So the researchers discovered that gives title to the university, subject only to John Moore's right of occupancy. The court starts out by saying that while the cells and tissues are parts of your own body, they're yours. In a sense, you have property in your own body. But the court distinguished between your own body, right, and the dispositional control you have over your own body, and that of excised tissues and cells. So once excised, discovery gives the exclusive right to extinguish Moore's interests by consent and by patent. Oops. So I'm sorry. Here we go. So it was perfect timing. The court's decision and the court's analysis aligned perfectly with the interest of the biotech industry. And certainly California was a major hub of that emerging industry. In large part, that industry's formation had been facilitated by 2 things. One is the Bayh-Dole Act, a federal law passed by Congress in 1980. And the photos on the left depict Birch Bayh, a Democrat from Indiana, and Robert Dole, also a senator. On a bipartisan basis, they passed this law. And in effect, what the Bayh-Dole Act does is it says that the patents that are based on federally funded research could be exercised by the universities to form partnerships with commercial enterprises. And the idea was that it was a way of facilitating and speeding up the process of getting research from the bench to the bedside. So it grew this idea of tech transfer, which is why all research universities now have a tech transfer office, if you will. In 1990, the same year that the Moore case was decided by the California Supreme Court, the United States launched the Human Genome Project in collaboration with other countries, but $3 billion worth of federal funding went into this effort. And the goal was to set out a map of the human genome. And in combination with the Bayh-Dole Act and the Moore decision itself, it launched a gene rush. So in translation, what the Moore case does is it says, well, you have to disclose and get consent for the use of cells and tissues. And if you do so, if you, the researcher, and your research institution do that correctly, then you're free to use those cells and tissues and exploit them and profit from them. So this is a photo of part of the consent form, part of the patient services agreement I sign every time I go to see my UC doctor. So anytime I go for my annual checkup or any other kind of service, I'm asked to sign a form. It's a one-page form, and buried in the middle of paragraph 4 is the language that I've highlighted here. That's the more clause. So these more clauses have become fairly common, especially within the UC system and many other healthcare settings. So it authorizes the university to save and keep and use and exploit and profit from any of the cells and tissues that are collected in treatment, in the treatment process when I go to the doctor. And that's how biobanking is largely done. It's not the only way, but certainly biobanks are largely formed from the cells and tissues collected from patients, often in the course of treatment. And often without them having read the sentence buried in the middle of paragraph 4 of their patient services agreement. So more became biotech's favorite case. Disclosure and consent became a rule integral to tech transfer and biobanking, and more enabled the accumulation of human tissues and genomes as capital assets. So now the question is, but what about race? I said genetic race, right? So I brought in the genetics, but what about race? And how do we get to genetic race specifically? So the Human Genome Project mapping was started in 1990. It was finished by 2003. And a key finding was that, I'm sorry, this is my biobanking slide. A key finding was that sort of race is not a particularly powerful explanation of racial difference. And for some researchers, it's not an explanation at all. It's not a useful explanation at all. One of the data points that was announced and spread widely during this early period of time was that there is more genetic variation within racial populations as we define them in the United States than there is between racial categories as used in the United States. Or as Dr. Craig Venter, who was one of the key actors in the race to map the human genome, said, race is a social concept, not a scientific one. And yet the gene rush resulted in this concept of genetic race. So the question is, how did that happen? How did that happen? So I think one factor is what emerged from this sort of hoopla over the genome, not just the mapping of the human genome, but the idea of the genetics are really, really important, not just to explaining illness and health, but they also provide the key to describing and identifying who we are. That concept is called genetic essentialism. So genetic essentialism is part of it, but that doesn't necessarily explain the part about race. How does it become genetic race? I think there are a couple of other factors at play. So one is that it's a timing issue again. In the mid-1980s, the National Institutes of Health launched 2 task forces, the Task Force on Minority Health and the Task Force on Women's Health. And both of those task forces found that gender and race were not being tracked in terms of accounting for healthcare disparities. And they made a series of recommendations. And those recommendations were implemented, or at least they began to be implemented in the 1990s at the same time that the genome was being mapped. So when the data proving that there are healthcare disparities by race and by gender started emerging in the 1990s, the question then becomes, what accounts for these healthcare disparities, right? And the gene becomes the easiest explanation to look to. It's right there. And maybe it's amplified by the fact that so much funding is going into genetic research that the genome as an explanation develops this sort of financial and almost magnetic pull, if you will. So you have that. I think that's one factor. And then the other part of it, I think, is something that medical anthropologist Sandra Sujin Lee has seriously considered in her own work. She has a really interesting piece in which she talks about biobanks as political artifacts. And in fact, that's part of the title of this article. that I'm quoting here, and it's from September 2015. Part of what she did in that research was she tracked several biobanks, and in particular, a biobank that was set up by the federal government to facilitate and speed up identification of single nucleotide polymorphisms, or SNPs. Single nucleotide polymorphisms are the basis of most genetic variation. So the idea is that they set up a biobank to facilitate that research. They could sort of multiply the number of genetic variations that were available for further research to find out what they did, what explanations they provided, and what treatments they might lead to. So when the NIH set up this biobank, they stripped out identifiers, including racial and ethnic identifiers. They made it, quote unquote, colorblind. And that's the term she uses in her article. And yet there was an insistence by the researchers that they needed that information. So the researcher would say, on the one hand, and this is what this quote reflects, it's a quote from one of the researchers she interviewed, right? They would say, I know race is not a significant explanation, that it's not a powerful explanation of genetic variation, but I want to know. It's part of the subjects. Researchers want to know what they are dealing with. So while race has no power to explain genetic variation, it does power the way we see and ascribe difference. The story of Henrietta Lacks and the HeLa cell line illustrates that point. So thanks in large part to Rebecca Skloot and her book, we now know something about Henrietta Lacks, and much of the outrage in response to that story has focused on the lack of informed consent. And consent, of course, is a very important principle. It was upheld by the case in Moore, but the Moore case also illustrates that voluntariness does not intervene in racialization. So Hannah Landecker and her work has shown that the cell line was created in the 1950s and was used widely from the 1950s, the HeLa cell line, cultivated from the tissue samples or the biopsy conducted for Henrietta Lacks. When the identity of the donor of the cells or the provider of the cells for HeLa became known, the cell line itself became racialized. It became part of the description of the cell line. So the cell line from 1966 was described as aggressive, out of line, ungovernable. So in terms very, very similar to the language used by the Supreme Court in Johnson versus McIntosh, in fact. So now consider the role of dispositional control acquired by disclosure and consent. It gives the owner the power, the owner of the cells, the tissues, in other words, the biobank, the patent owner of the cell line, whoever it is, to the power to classify and label. So biobanks deploy the appeal of representation, a democratic ideal, and they market diversity when they're selling their products. So this positions the end users as consumers, often with little choice but to make racial selections. And this plays out in the market as well. So part of what this shows is that there's a recently launched effort, again, by the federal government, by the United States, to collect 1 million genomes from a diverse range of donors. And in part, what you see on this slide is sort of the appeal made by using terms of representation, right? We want widespread representation. We want you in here for those of you who felt unrepresented before. The description of the All of Us project also says that they're considering factors outside the body, like lifestyle, for example, and diet. But it's, as I said, it's using this appeal of racial representation, but it's using these words, genetic diversity right? In combination with images and other messages, which make it very easy to assume that what they mean is racial diversity. It's a very common practice by biobanks, both research biobanks and other types of biobanks. So the all of us messaging, like other biobanks do, conflates genetic diversity with racial diversity and perpetuates this belief in biological race or genetic race. Other consumer-oriented biobanks also sell genetic race. So egg agencies, for example, advertise that you can find, right, sort of the eggs of the right race if you want them. This is a sperm bank website. And usually for most sperm banks and egg banks, it'll give you sort of an initial short list of selections that you can make to sort of narrow down your choices of genetic materials that you're looking for. And race and ethnicity are usually near the top. They're usually in the top 3 sets of choices that you'll make. And they use these racial categories, even though those are not genetic choices that you're making. Direct-to-consumer genetic testing does something similar. So in another paper that I'm working on, I use the term ethnicity estimate, which I got from ancestry.com, and the population geneticists in my work group jumped all over me and said, that's not a thing. And I said, well, it is on ancestry.com because that's what they're offering. So again, sort of this sort of idea of genetic race, it sells. And so it's being offered as a product, as a selection you can make. The work by Kamisha Russell, who's a social scientist up at University of Oregon, she's written this really great book and done really great work. And she's used some of assisted reproductive technologies. And she says, you are flooded with choices, more choices than you would ever want to make, and yet you're forced to make them, including the choices about ethnicity and race. For example, when you're choosing a gamete provider. So I guess the question I want to raise is that I don't have a neat solution. It's just a question. This is a big, messy problem. I think in part what I want to point to is the problem with biomedicine itself. Biomedicine, for the most part, is inward looking. It defines health, illness, and anything affects health or illness from the skin inward. So now we're down to the molecular level, right? The base pairs in our genomes, if you will. So we've looked wholly for explanations within the body. So the phenomena of genetic essentialism is not a surprise. It follows from the logic of biomedicine. And the question now is, how do we get biomedicine to look outward? How do we get all of us to look outward, to take up this challenge that's made so clear? I think we have a real opportunity with the attention now raised by an actual widespread national discussion about the role of structural racism in health. But the main point I think I want to sort of end on is maybe one small step we can take as we think about this big messy problem is to walk back the rules that deprive us of dispositional control and categorization of our own cells and tissues, to drop the line, the distinction between excised tissues and those that remain attached to our own body. So I'll end there. Thank you.
Thank you so much for that fascinating lecture. We are enriched from your presentation, and I wanted to just point out that I'm going to be keeping the queue. So if you don't mind using the raise your hand function, and then I'll call on anybody that has a question. And you can also use the chat function to put in any comments or thoughts that you might have. And so I can take moderators prerogative and go first. And so I was thinking and reflecting on how ubiquitous the use of sort of race as biological is based on your presentation, and then just observations and some of my own work. And so I'm wondering how you get to challenging that, race as biological from where you ended with being able to have more control over sort of excised tissue, right? So I guess I'm pushing you a little bit on the sort of prescriptive.
Yeah.
What is it that we can do to actually sort of really significantly trouble biological understandings of sort of, yeah, race as some immutable genetic thing?
Yeah. I mean, I think part of it's the power of labeling. And I think there's a difference between, for example, claiming my own identity as an Asian American, as a Japanese American, a third generation woman of color, and having a biobank label my tissue samples in that way, in a way that conveys that scientifically meaningful, right? Because I don't agree to that point. So I think for me, sort of allowing me to sort of say what's relevant or not to the scientific enterprise is a way of doing it. Maybe some people believe in biological race and they would still have that included, but I think that's part of it. It's about just sort of pushing back against the sort of power, right, that's been given to the techno-scientific enterprise. It's a little bit. I mean, there was a really interesting article in the New York Times last week, and it talks about a debate that's taking place among forensic anthropologists. And it's also about biological race. So there's some real questions being raised by forensic anthropologists. They have longstanding practices where they're presented with a skeleton for police purposes, for investigation purposes, for example. They're asked to come up with some information so that they have identifiers. And they can put together a profile of that enables it to find out who this person is or was. And there are these long-standing practices that have been used to say the skull is Black or white or Asian, right? Or American Indian, right? Native American. And there have been questions that maybe those aren't so accurate. It turns out they're not. And while forensic anthropologists and population geneticists, for example, have tried to push back by using the term ancestry, and I think to some extent, like the direct-to-consumer companies like Ancestry.com have pushed back a little. They could have said, you know, race or ethnicity heritage instead, but they use ancestry. They're still being used in ways which make it very easy, right, to translate that into racial category, right, or racial history. So now the forensic anthropologists are considering using a term instead of ancestry, and the term they're proposing is population affinity, which is also a term being used by the population geneticists as well. And it might be that changing the terminology might not help. It's a small fix, maybe it's a temporary one, maybe we'll end up with the same conflation, but I think at least troubling the waters prompts at least those who have the power to label to have to explain what they're doing. So those are small things, I think. I don't think they really fix the problem. The problem is outside of biomedicine as well.
Yeah, of course. Thank you. Thank you for that. Karen, I see your hand, and then there's a question from Bob. So we'll go to Karen and then Bob's question.
First of all, thank you for a really thought-provoking presentation. Really, really good. Okay. So I'll just give you a perspective that I don't have the answer, but it's a perspective sort of watching this through biomedical research for the last 40 years. And I think we're on a collision course because on the one hand, as you mentioned, in the 80s, there was a big push both to enhance gender and racial inclusion in biomedical research. We didn't have data except on white men. And so it was almost like an affirmative action push. Every research proposal needed to show how much inclusion there was of minorities and women. So we had that move, which I think was made in good faith. And against it was this worry about stigma that was associated with studying each specific group. Just by analogy, you know, when BRCA1 research was being done and it started to be seen that Ashkenazi Jews had a much more significant percentage of this BRCA gene. You know, there was stigma associated with this, or what we call redlining or whatever. And yet, on the other hand, it provided a lot of interesting and potential positive research for certain communities. And I think and more recently, I think your point for all of us, which is a major push to expand the diversity of our data, is a direct response to communities saying to the genome community, hey, wait, all this research is being done on your, Caucasian people, men and women. And we're making conclusions about diseases just based on very limited data. So that's like a collision course. I don't know the answer to it. I don't know the name of what to call it. But when Francis Collins used to say, the good thing about the genome is that we've learned that we're 99% the same. Well, the devil's in the details on the other 0.1%, right? I mean, we know that back from eugenics. So I don't know whether this is a question or a comment, but I would really like your perspective on it.
Yeah, no, I think that's a really good point. It's been this sort of ongoing problem since the early 1990s when that data started, when they started collecting that data and proving, right? On the one hand, they proved there are these really significant healthcare disparities by health, race, and by gender, race, and ethnicity. It provides an opportunity to try to think about what are the causes and what can we do to address them. And as I said, I think the initial turn was inward, right? There are all kinds of directions we should have been looking at in the meantime. What's the role of environmental toxins and who lives closer to those toxins than other people? What's the role of racial segregation, residential racial segregation?
Okay.
But
And
little of
that
that research got funded. Most of the research went inward.
Right,
So
because that's
part of it.
very hard research to do.
Yeah.
Very hard, not sexy at all.
And
but
corporations don't want that to happen.
They don't want that. But you're absolutely right. And all those other things really support structural racism. But it's probably not all or nothing. It's probably
I don't
just
think it
more
is.
complicated. Yeah.
I don't think it is. But I think it is an opportunity to think about, there's certainly, this is being done at least here and there in discrete manner. So there's probably some really good models out there, but to think about how, when you frame, how do we frame issues in biomedicine, right? How do we frame it with racial justice in mind, right? How do we frame biomedical research questions from a feminist perspective? We have the Feminist Research Institute on campus right now is engaged in that process, and they're working with the biomedical researchers on campus, and they're coming up with some really interesting projects. It requires different kinds of collaborations with public health, for example, or city planners, those kinds of things. But, I guess what I'm trying to do is sort of push and encourage those types of more open-ended questions. Probably more expensive, complicated.
It's definitely more complicated, and you have to get power at a different level, and that's why they need 1 million people, because that study is not just genetics, it is environmental. It's raising a lot of the points you make, but it's not easy to recruit.
Yeah, although all of this on its website really emphasizes, I have a somewhat of a concern because they're emphasizing lifestyle and diet. And so some of the research in the 1990s that started conversation, that's a very neoliberal take on causation of health and illness, right? It's personal responsibility. What have you been doing? What is your racial community been doing, right? What
as opposed to where you live,
these problems?
As opposed to where you live and where you work.
Yeah, exactly.
There is a growing queue, so I want to make sure we get some others questions. So I think Bob was the next question. Bob, did you want to read your question? Do you want me to? I can.
Why don't you go ahead?
Okay, thank you.
Hi, Bob.
So Bob's question is, is there a potential conflict between legal protection of genetic information and ownership and use of excised cells by third parties?
I think it's still possible to allow control over the excised cells and tissues and yet allow others to patent them. But it has to be done by, I mean, I guess my point is that the principle, the ethical principle, and hopefully the legal principle is that that's done by agreement.
Thanks.
Did that answer your question, Bob?
Sort of.
I mean, most people, it turns out in the surveys that when most people are asked up front, not buried in the middle of the fourth paragraph, asked up front, would you donate your cells and tissues for research? They'll say yes, they want to help. And so, you know, I don't think that this would necessarily prove to be the financial disaster that the California Supreme Court thought it would be.
Thanks for that. Diane, you're next on the queue.
I'm gonna actually hold off until if everyone else gets, because I can ask Lisa later. Not enough.
Sure. So Leah, you're next, and then we'll have Keisha go.
Thank you so much. Hi, Lisa. Great.
Hi, Leah.
Thank you so much for that wonderful presentation. I found it really so illuminating of the different factors from your, disciplinary perspective, contributing to the reemergence of, biologicization of race. I would love to hear a little bit more about, you mentioned your DTC genetic ancestry project. I'd love to hear a little bit more about that. I am currently working on a project on YouTube performances, genetic ancestry test reveal by YouTubers. And also from this perspective of to what extent are people kind of making the assumption equation between racial identity and what's in their DNA test, right? And it seems that on the whole, people are making these kind of direct relations in their performances. Whether or not that has long-term identity implications is a different question, but I'm looking at, as a folklorist and anthropologist, specifically in cases where the test results conflict with family narratives, what's the outcome?
Oh, that's interesting.
Some of the young people actually call up their parents on camera to ask about the conflict. And so I saw really a trend of these younger people in their 20s and 30s accepting the test results as conflict, so saying that they were thinking that they were lied to by their families, whereas the parents were more hesitant to trust the DNA narratives over their grandmother's stories, for example. So it's just this really interesting dynamic in the public as well. And I also found that on, Henry Louis Gates' Finding Your Roots, those types of shows, in his presentation, he actually equates race with the DNA. And,
yes,
so he says, are you, we're going to take this DNA test, and can you tell me, you have to predict if you will be white, black, red, or, in the DNA test results. So there's all of this bombarding stuff from the biomedical industry, from the entertainment industry, that everyday people are being sent this message that race is genetic, that it's in our DNA.
Yeah. And I think it's important to understand race is being used as a proxy, right, for ancestry, but we get this sort of direct equation in our heads, because the race, if you live in the United States, right, for any amount of time, right, race, these particular categories, right, are so salient to our lives that we just sort of jump to them. They're at the front of our brains all the time. I think probably everybody in this conversation here today, knows this, but not all countries and cultures use the same categories that we use in the United States, and they don't use them in the same way. But that's a really interesting story, because the way I think about it is, like I said, I identify as Japanese American. My grandparents immigrated from there, but I guess I wouldn't. I thought about it long enough, in conjunction with conversations with my colleagues in my study group, that, I think it's possible. We have this sort of running joke in my family. Half of us have wavy or curly hair. And you don't think of that as part of the image of what a Japanese American looks like. So we always joke, oh, it must have been one of those Portuguese sailor that our great, ancestor formed a relationship with. So I don't know for sure that I'm ethnically pure in that way. So there might be a different, right? That's the conflation of race. On the one hand, identifying as Asian and yet not necessarily genetically so.
And I think that's one of the main problematics of these tests too, is that they're assuming some sort of pure continental population that has never had any existence in reality.
No.
And these companies are presenting biogeographies that really harken back to colonial, dividing up the world, and continents were equated with races. So there's almost, no matter if you're changing the vocabulary, there's really no way, I don't think, to take race out of that equation as long as you're still looking at these templations that are equated with continents and colonial continental geography.
Yeah. The other piece I'm working on is about sort of assumptions of racial purity. And it's sort of, when we look at maps, we assume racial purity depending on sort of where on the map we're looking at. That's never been true. There's been too much human migration.
Okay, we have Keisha next. Keisha, I can read your question if you are not available. Keisha's question is about journalists who cover universities or general science as beats, and they don't usually get to the broader discussion of human experimentation until it hits the courts. So she was wondering where else might investigative reporters begin to uncover more instances such as the informed consent issues you discussed surrounding Moore and Henrietta Lacks.
So it's specifically those kinds of sort of non-consensual use of cells and tissues.
Yeah.
I mean, the interesting thing is, well, so there are several cases. I mentioned the Moore case. That was one of the earlier cases. I mean, I think the question now is, what if about for people, not me or my students, because every one of my students has seen that clause now. So now they're all inspecting their patient services agreement. But most people aren't reading, right, their informed consent forms that closely. They're focusing on the things that are relevant to the time that they're making a medical decision, right? And so it might be that they sign the consent form and legally they've given consent, right? But they had no idea that they also consented to the use of their cells and tissue by this research institution, and that it might end up in a database. So I think that's actually an important issue that hasn't been fully addressed. And I'd love to see an investigative journalist get onto that.
So we're getting close to our end time, but I wanted to make sure that we at least hit some of the questions. And so I'll read the ones that are in the chat and then let Jovel ask you, and then you could just do a summary response to them.
Okay.
So one question from Petra is just really just talking about how you made a great point about highlighting some of the breakthroughs about our own thoughts and ideas and categorizing and binaries. And it's really just a comment about how science isn't neat and orderly as we'd like to think in terms of presenting data. And then Anne had a question about the ways in which Black and white standards are benchmarked for pro football retirees in terms of brain damage, and had a comment about how, essentially there's consensus that that shouldn't be the case and that there should be a single standard. And so wanted to see if you could comment on that. And then Joel had a question. Joel, did you want to ask a question?
Absolutely. Thank you so much. My name's Joval. I am in my 4th semester in the CNL, the Masters of Science Nurses Clinical Nurse Leader Program. I'm so thrilled to have signed up for this. Glad I saw it in the Elm, because as a student, but especially now as a nurse, as a nurse I am transitioning from teacher and other fields to become a nurse, because race is the one thing that has clearly always negatively impacted my health, right? It's never been insurance. It's never been literally anything else. And so one thing that I am grappling with is, how do I and my classmates, how do we continue and have these conversations in spaces at Maryland in our program with people, with professors who don't want to have them because it makes them uncomfortable.
Yeah.
So however are we to even address systemic medical racism, right? Medical racism, any of the isms, when we can't even agree on having conversations that for some are difficult, and I understand that. How do we lower that threshold, and also the cognitive dissonance that comes with that, because language matters. And so for people
Yeah.
who say it doesn't, also still, regardless of education and status, we are going to continue to encounter these people, right? And so how do we fix this broken system? Or quite honestly, to be honest, the system isn't really broken because it's also functioning quite literally how it was built and intended to function. So
Yeah.
can we work collaboratively to chip away at this major, major problem?
Yeah, that's a really, really good question. And I think it's actually connected to the other points that were made in the chat as well. That those points just show that it's biological race, but also ways that race intervenes both structurally, institutionally, and also interpersonally, right? And then it comes from this sort of pseudoscientific concept itself. I don't know that I have an answer to that, but one is to sort of start by talking about something that's clearly not within the control of the people you're talking with, right? So you start talking about an example, right, that they had nothing to do with, but which enables them to see that race plays a role. So one of the examples that I used recently was that at the beginning of the pandemic, right, there was a lot of talk about the need to use pulse oximeters to measure oxygen levels, because it wasn't always you couldn't always measure someone's respiration by what they were reporting in terms of difficulty to breathe. But then it turns out that we've known for years, or studies have shown for years, that pulse oximeters don't work accurately on people with darker skin, right? So they were tested and developed on people with lighter skin, and because pulse oximeters work by, you put it on the surface, right? Typically on a thumb or something or the toe, right? And it counts the sort of number of blood cells carrying oxygen, right, in the system. I think that's how they work. That's what was told to me when my son had one attached to his toe, right? And so it's harder for them to read through darker skin. It's more opaque to this particular device. So that's about device development, and nobody I know had anything to do, right, with device development. And how is it, right, that we didn't know that, and that it didn't become sort of widely acknowledged until 2020, even though the studies have been around. So maybe that's one way. You find examples, discrete examples, that are not necessarily about blame, right?
It's because it's never about blame, right? I mean, for me, it's never about blame. It's really just
But I think it's received as that. I think in conversations about race, that's part of what the discomfort is, right? It's a feeling that, oh, I must be responsible. And it's a form of fear, right? Because racism, I think most people will say racism's horrible, right? They don't want to be complicit in it.
Right.
Yeah. And the other thing I do, and sometimes this works, especially with my students, is I start out by saying I'm racist. That I was born and raised in this country, and every day I have to work, and every day I find ways that I need to improve, right? And I could give examples from different points of time. I used to think this, right? And I had to work to change that, right? And 5 years from now, I'm going to find out that the things I'm doing and saying now were wrong, right? And you can say that about racism, sexism, something else, right? So it's sort of, you can maybe start a conversation by saying that we're sort of, race is culturally constructed. We are all part of this. Yeah. There's nobody outside of it in a society like ours. Yeah. I don't know if that helps.
No, it absolutely does. It absolutely does. Thank you for that. Then can I ask one tiny quick follow-up question?
I know we're at time.
Actually,
I'll send an email. It's fine.
Okay, feel free to do that.
Yeah, I'll send an email.
I feel really bad ending the conversation because I just asked if I could end the time, and I was told no. So I I really would like to stay to continue to pick your brain, Lisa. This has been such a fascinating conversation, but I think part of, the hallmark of a great talk is that there's, the talk is so generative that you have more questions and comments than you actually have time to. And so thank you for offering to be able to respond to folks if they want to follow up with you individually. This has been a great
Please do
pleasure.
contact me.
Yeah. And so thank you for your time and your brilliance. And then Diane, I don't know if you have any other sort of quick announcements before we sign off.
Just again, thank you to Lisa. That was just such a fabulous talk. Really, really great. And thank you to all of you for joining us today. And I hope you'll be back for the other speakers in our series next semester. So take care, everyone. Stay healthy.
Thank you very much.
Thanks, Lisa.
Thank you so much. Take care, everyone. Bye-bye.
Bye.
Great. Thanks so much.
Thank you so much.
Thanks for a great presentation.
Thank you. I
Excellent.
really enjoyed the conversation. It was great to see everyone.
Great to see
We
you.
had such a lively chat and Q&A lineup. So that was good. That was really
Yeah.
good.
And I got to see some old friends.
Yay!
That's always fun.
Yeah.
There's a lot of food for thought in what you said.
Thank you.
We have to chat more. Thank you, Lisa.
All right. Take care. Bye.
Take care.
Bye.
Thanks again.